I'd like to talk for a minute about the powers of attorney documents that should accompany any robust estate plan that you put in place. Any will, any trust plan should always be accompanied by powers of attorney. And in fact, if you choose not to do a trust or a will and just to allow the Missouri default plan to be your plan, you should still have powers of attorney because the Missouri default plan does not address incompetence issues. It only addresses issues from passing away. We'll talk first about the general durable power of attorney. Now, the word durable simply means you put it in place when you're competent, and if you become incompetent, that document doesn't lose its authority. That's what the durable means. If you become incompetent, it doesn't evaporate, if you will. And you always want it to be durable. I can't think of a single reason why you wouldn't. I mean, that's exactly the reason why you put it in place generally, is to protect against your incompetency. I suppose you might want to do it if you need to authorize someone. Mike probably sees this in the mortgage world. You might need to authorize someone to sign legal documents for you, so you might put one in place for that reason. But in the estate planning world, we always want your power of attorney to be durable. The power of attorney for finances and the power of attorney for healthcare really should be two separate documents because they cover completely different sets of circumstances. In the olden days, meaning even as recently as 10 years ago, you would often see these documents combined into one, and that gets kind of cumbersome. There's not a lot of good reasons to do that. It's better to keep it clean and keep them separated because you don't really want to have to go to your bank and hand them your power of attorney and, show them what your plan is for your health care. You want to just keep that separate. Powers of attorney are documents that allow you to say who steps into your shoes to make decisions for you over your financial life when you're no longer able to do that. And that person that you name is called an agent or an attorney in fact. I don't like to use that term because people confuse it easily and understandably with attorney at law, which is what I am. And I don't want them thinking that by naming a power of an attorney in fact that they're naming me to manage all of their financial assets. That's not the case at all. So I like to use the word agent. And I also like to have my powers of attorney effective immediately for a spouse because you're kind of commingling all of your financial life anyway. Make it immediately effective for your spouse. But anybody other than your spouse or your significant life partner, their powers are only going to be effective either upon your incompetence and your spouse can't do it for you anymore, or if you specifically authorize them to be activated for some reason. But in my experience, there's usually not a lot of reasons why you want anybody other than yourself and your spouse authorized to make your financial decisions for you, unless it's on a very temporary basis. Let's talk about power of attorney for health care. Again, the person that you put in place to make decisions for you is usually called an agent, a healthcare agent. These documents are not effective when you're able to make your own healthcare decisions. They only get activated upon incompetence, and it usually requires a doctor to make that decision, although you can choose in the language of your document to say that that decision gets made in some other way, maybe a panel of people or your spouse. I mean, I'm most comfortable naming the doctor because they usually have a better set of tools to determine if you're incompetent. Some people don't want it to go through the doctor and would rather have a rule that applies to or is applied by a loved one or a couple of family members. Healthcare durable powers of attorney really became in our consciousness as a society back in the 90s, and I think it's safe to say that all of us are old enough to remember the Terri Schiavo case. Does anyone remember? It's a really sad set of facts. Terri Schiavo was a young lady, 26 years old, when she suffered a terrible heart attack at 26. it deprived her brain from oxygen, and as a result, she went into a coma, and she became in a vegetative state. So she had two things going on. Terry was married and had a husband that loved her very much, and she was young enough that really her parents were still very involved in her life and loved her very much. And when she had this horrible event happen without a healthcare directive in place, her husband and her mom and dad had a very different opinion about what should happen to her. Should she stay on life support indefinitely, or should the life support be withdrawn and she be allowed to allow the natural course of dying to happen? They ended up fighting over that decision for 15 years. And during that time, she was removed from life support and put back on life support, a total of put back on 3 times, removed twice, I guess. And it wasn't until the US Supreme Court, they fought it out in court because that was the only way they had to make a final decision, and the hospital needed to know that what they were doing was the right thing to do, and the court had to say it. But the US Supreme Court decided to not hear the final appeal, and so the court, right before the Supreme Court, their decision stood, and it was the husband's request that life support be removed. So it was, and by that time she had emerged from the coma, and so she had some eye contact, some eye blinking going on, but still no brain activity, but she had, some things going on in her body that made it seem like she was interacting with the rest of the world. So really made it a hard and horrible choice, but ultimately the life support was withdrawn and she was allowed, and I think in her case it was more of a feeding tube issue than anything. It was removed and she was allowed to die naturally at that point. Had Terry had the opportunity to have a written healthcare durable power of attorney in place before that horrible day, then it would have spelled out who had the authority to decide life support or no life support. Would it be the husband or would it be the parent? And they could have avoided that 15-year struggle.